The Fifth Circuit ignores 100 court opinions criticizing Reliance Standard for its claims handling in upholding Reliance Standard's convoluted determination of a policyholder's occupation. Even a long history demonstrating a carrier's routine unfairness to a policyholder or policyholders doesn't seem to result in a win for a wrongfully denied policyholder in this case. Now, Reliance Standard Insurance Company has been a bad actor for years with a notorious history of biased claims administration, as was noted in the case of Nichols versus Reliance Standard Life Insurance Company. The Nichols court cited over 100 opinions in the last 21 years criticizing Reliance disability decisions, including over 60 opinions reversing decisions as abuse of discretion or arbitrary and capricious. Now, the district court in this particular case awarded benefits, and Reliance took it to the Fifth Circuit, who amazingly reversed the award and entered a judgment in favor of Reliance Standard. Let me tell you the story of Miss Nichols. She had been employed at Petco Foods, which is a chicken processing plant, as a hazard analysis critical control point coordinator. Her occupation exposed her to temperatures of 40 degrees. She had Raynaud's phenomenon, which is a circulatory disorder that can cause gangrene if you continue to work in a cold environment of a plant such as this. Now, the policy defined the term regular occupation as the way the job is normally performed in the national economy, and not the way it's performed for a specific employer or in a specific locale. So what did Reliance do? Well, in an effort to deny benefits, they hired a vocational specialist who opined that under the Dictionary of Occupational Titles, exposure to cold was not a material duty of her regular occupation, and that she was in fact a sanitarian. Under the DOT, the material duties of a sanitarian don't include employment at a poultry processing facility or even exposure to the cold. So of course, Reliance got what they wanted and they denied her claim. She appealed. Now, Reliance's peer review doctor opined that she didn't really have any physical limitations, but rather environmental limitations. A second vocational evaluator for Reliance confirmed her occupation as a sanitarian. Now, this is the same game played by Reliance in all of its cases. It will misclassify the occupation and then find a doctor to opine that there are restrictions and limitations that are such that they could work. So what did the district court do in this case? They found her occupation was a cool room worker. Now that definition captured her meat inspection and packaging duties and not just her sanitarian duties. But the Fifth Circuit reversed, saying, look, Reliance doesn't need to account for every task Nichols performed in assessing her regular occupation. Really? Reliance only had to make a fair and reasonable determination of her occupation and whether or not her disability precluded her from performing the material duties of her regular occupation. Clearly, the Fifth Circuit didn't read the 100 cases that outlined this same conduct over and over. The Fifth Circuit is complicit in this improper claims handling conduct, and it rewarded Reliance for their bad behavior and encouraged continuing bad behavior. I think that the decision in this case is nothing short of outrageous. If your Reliance Standard claim has been denied, contact me at 727-894-3188. I'm not afraid to take on Reliance Standard and their bad behavior.